Everybody, welcome back to Dad Talk. I got attorney Chris Smith on the show with us tonight. We actually got a surprise guest. It's the holidays. It's supposed to be full of surprises. So right before we get into it, guys, thank you for giving us all the voicemails tonight. We're going to get to all the questions that came through tonight that were pointed towards Chris. If you'd like to get on the next show, I'll be rolling tomorrow morning at 10 o'clock a.m. Eastern, and there will be a replay of that at 8 p.m. Eastern tomorrow night. Give me a call, 762-441-0281. If you didn't get that the first time, it's scrolling down at the bottom of the screen. With that said, guys, before we get into this, of course, like I said, I got a surprise. So you're going to hear from more than one attorney here tonight. But nothing about this is legal advice. It does not create a client-attorney relationship, but you are asking your question to an attorney. So with that said, let me bring the boys on. Chris and Tommy. Tommy, what's going on?
What's up, brother?
Hey, man. Kind of last minute edition. I love it.
I know. Merry Christmas, buddy.
I'm doing double duty as Dad Talk guest and dad with kids right now watching A Christmas Story. Wife is out. She had a dinner tonight, so I'm doing. So I figured I better bring in reinforcements and have Tommy on here just in case I need to go take care of spilled popcorn or something.
Yeah, man, absolutely. So, guys, I've said this several times before. There's not many attorneys I trust, but I met you gentlemen not too long ago. This is an amazing team right here, and I can't wait for you guys to hear from. We had on Chris not too long ago. So before we get into it, Tommy, tell everybody a little bit about yourself and how you got into family law.
Well, I am a divorced parent myself, and I always joke around that given my dad, may he rest in peace, his track record with the marriages, that it would be cheaper for me to go and be an attorney. But jokes aside, my passion is fighting for dads and fighting for equality among parents. I went through a tremendous divorce myself, and that kind of spearheaded my path in life to really gear towards law, and specifically family law, so that I could help other dads who have gone through it and are going through it, and co-parenting and all that other great stuff. So that's pretty much who I am. That's why I'm here. And I get to work with Chris, and we have a great time. There's wins and there's losses, there's highs and there's lows, especially when you're in the issues that you guys are talking about every day is something that we face in the court system day in and day out. And it is a very tough system. But for us, it's good to try and change it from the inside out and be a part of that. So I'm just glad that you do Dad Talk today, and I'm appreciative for allowing me to jump on here with you guys.
I appreciate you guys for that. This, like you said, this is a very heavy, serious subject matter that we deal with here, and some of the issues that come across us are horrendous. They really are. I know how kind of difficult that's been for me listening to all these people's stories. What's that like for you guys? That's got to be hard not to take home sometimes and to get it off of your head. Is there something that you've done to be able to detach yourself from it when you leave from the office?
Tommy and I are bad. We're bad to ask that question to you, because it's not unusual for us to be. I'll put kids down and kiss my wife, and we'll get on the phone, start talking about work. And so,
Yeah.
I think that one of the things that you have to do, and you have to be able to detach from, the emotional part of it, but also you have to be willing to kind of lean into it a little bit and just make it part of, it's just life. I mean, at this point, I fought being an attorney for 15 years. It seems like, and then, when I really leaned into the representation of dads and the work we do, that's when I started having fun with it. I started enjoying it. It became more of a cause and a mission than just work. And so that's the joy of what we do and we get to do. But yeah, it's emotional. So and Tommy's a young attorney. He's only been doing it a few years, but I mean, he's wise beyond his years, and his personal experience and life experience brings a whole lot to the table that others don't have after 20 years of practicing law. And so, him, and then our other associate, Sarah Willie, who's not on here, but I'm sure she's watching. I take a lot of personal responsibility in making sure that they don't fall prey to the emotional toll of this practice area. So we do what we can.
Sure, it's very easy to do too. Guys, we got several voicemails, so I want to hop into those. But before we do, one last question before we do that. I didn't realize how bad this issue was at the holidays in my first year doing this. Like the week or the day before Thanksgiving of 2019, our inbox just got slammed. Temporary restraining orders, told they can't pick up their kids from school, the whole 9 yards. I think Robert Garza has coined it holiday hijacking, because a lot of times with the holidays, there's not much you can do. The courts aren't open. Is this a problem for you guys? Is this something that you see? And if anybody is going through that, what would be some advice you could give them?
Tommy, jump in there.
It is something that we see, unfortunately. I like to call it the holiday opportunist. And what they do is they see the holidays and they try to win their case by, hey, it's either a false allegation or it's confusion over the order. Whatever the reason is, the best thing that you can do is document. Do not fall down to their level. It's easy as humans. We want to fight back. We want to defend ourselves. One thing that I did was probably not the best advice at the time when I was going through my divorce is, get emotional. Give me my kids. This is the kids. I'm supposed to have the kids. Give them to me. What you want to do is take a step back, look at what the order is, make sure you have all your ducks in a row, and then continue to document. Speaking of kids, there's a little one there. You're live.
See, I knew this was going to happen. She was making a little too much noise, so I wanted her to come see that we were actually trying to get some work done.
Hey.
You say hi to Mr. Eric? Okay.
I told you gave her ice cream a little too soon there, Chris.
Yeah, that's exactly true.
But no, what you want to do, you want to document everything. So make sure that you document everything. Try and contact if you're represented by counsel, make sure you talk to your attorney. Depending on the situation, sometimes calling the police, but as everybody knows, and the commenters will probably surely point out, 9 times out of 10, law enforcement is going to say this is a civil matter. So where that leaves you is you need to document. Don't try and over document to the point of where it could be construed as harassment. Just make sure that you document and make sure that you get it to the court or your attorney as soon as possible.
Absolutely, man. And that was a good point that you brought up. This is a very high emotional thing, especially when it's hitting this conflict around the holidays when you're wanting to get together and see family. Guys, don't go back and forth with them. And I think sometimes I've had some of them get upset. They're like, you're telling me to be silent. No, I'm not. Fight it in court, document it. But can I ask you guys, have you seen any solutions come from these parents arguing with this parent that's making these allegations?
No, I mean, there's one of the tough things that I started telling parents early in my career is that anyone can file anything for just about any reason in a court of law. And you have to live under that understanding. And that's one of the things that we have to deal with. And so if someone's willing to go file a case, it's up to judges to hold people accountable for bogus filings. And sometimes you get judges that'll hold them accountable. Sometimes they won't. One of the things that we try to do, and we've done, I think, a fair job in most cases where we saw this coming, is we plan for holidays in advance and make sure that we're out trying to get out in front on holiday issues, make sure that it's something that we don't wait until the week of to try to address, and that we have a clear understanding of what's going to happen. And that's the first step that we try to do. Tommy's absolutely right. Everything that we talk about in a lot of the questions we're going to get into has to do with documentation and document.
Right. That cannot be stated enough, I believe. You know, it's not about all the time what you can tell them it happened. You got to be able to prove. You got to be able to prove every little thing that goes on, guys. But I am going to get into these questions. I appreciate everybody for calling. Let's get into this from our first caller.
Hey, Eric, this is...
Wrong one.
Hey, my name is Wei, and I'm from Malaysia and currently in California. I do have a questions about, I have an upcoming custody trial coming up, and my wife has made allegations, like crazy allegations, that she's afraid of me, that she's afraid I will kill my kids and kill her and kill her mother. And I went and got the mother's, which is my ex-mother-in-law's, restraining order against the father-in-law. And it's almost exactly the same, word by word. And how can I use that for my trial? Like, this insane allegation that I believe it was written by the mother-in-law and trying to take the kids away from me. And yeah, so that's my question for thank you.
All right. Did you guys pick up on what he was asking there?
Eric, can you give us just the highlight? I think I got the bulk of it. It sounded like that there was a protective order filing maybe against him, or tell me what it sounded like he said.
I couldn't tell if he said it was a protective order in there, but it did sound like he said, you know, X was saying that he was going to hurt them, could, you know, harm them. I think he might even say kill them or something like that. And something about sound like it was a statement made up by the mother-in-law. I could be getting that wrong, but that was kind of what I was picking up on there.
Let's I think that what he asked too is how he can use or how he can prepare maybe for trial. And one of the things that I think that every case that we're going to look at or that people have posted on Dad Talk and that we come across, there's an allegation that's made. The person who's making the allegation has to come into court and prove that allegation by a preponderance of evidence. And they have to prove their case. And one of the things that when you're documenting what has transpired, whether it be through text messages, emails, phone calls, recorded messages, you're trying to document the fact that there's no basis for what they're alleging. And that's what we're trying to get at here, is that there's no basis for the allegation. And when you go into court, the only thing you can do as the litigant is to put your best foot forward and to present the evidence that's there. And you can't control what the other side does. You can't control what the judge does. And the only thing you can do is control what you do. And if you're doing everything that you can as a dad and as a father to be the best father that you can be, and you're documenting the evidence that's there, you're doing everything you can. And then now it's just a matter of putting it in front of a judge and letting the judge make the decision. And hopefully we've got judges who will look at evidence fairly, and they'll apply it against the standard of proof that's required and make decisions that are fair and correct. And that's kind of all we can do in any of these situations, especially when there's an allegation like that I think we heard. Just document it, put the best evidence that you can in front of the judge, and let the judge make the decision.
You got anything to add to that, Tommy?
I think just the one thing to remember is that, and we see clients all the time, they'll get an absurd, absolutely absurd allegation against them. And the first thing that they want to do, which anybody wants to do, if you get accused of something and it's absolutely ridiculous, you want to try and clear your name. Everybody knows the court system is slower than molasses. So what you need to do is take that step back. Instead of taking that step forward and saying, I want to get in there and fight, I want to clear my name, take the step back, look at it, each allegation for what it is, and then take each allegation and try and defend each one accordingly. But what you don't want to do is take that emotion from getting some type of absurd allegation and then give them ammunition so that they can say, look, we got this temporary protective order against him. And then now he violated that protective order. So everything that we said in the temporary order must be true. Don't give him any ammunition. So take the step back.
Absolutely. I'm going to get on to our next call.
Hi. I'll keep my name anonymous. I'm from Milwaukee, Wisconsin. I have 7 months with no contact with my children. The judge appointed a guardian ad litem, and this guardian ad litem is supposed to assign a professional to perform a psychological test on me. After the hearing, I contacted the guardian ad litem, and she let me know that this person that was going to do this evaluation, was retired. Since then, since September, I sent her a couple of emails, and she hasn't answered, and she doesn't answer anything at all, And I'm trying to, my question is, what can I do to make this guardian ad litem do something about this? Because it's clear that she doesn't care about the kids. She's just making everything longer and leaving me without my children. It's a little bit frustrating because no one can answer anything. It's just her. Everything is on her hands. And I don't know if there's a way to make her compliant or there's a way to file something so I can't see my children. I've never been accused. I've never been charged for anything in my life. And the only accusations that I have had has been for my ex-wife. This is the second time that it happened, and the first time everything was clarified that my ex was lying. The same guardian ad litem was appointed. After all the findings, she wanted to give the sole custody to my ex-wife. So, yeah, my question is, what can I do to make this guardian ad litem compliant and start doing something I can't see, and so I can see my children? Thank you.
First of all, he's got to get in front of a judge as quick as he can and force the issue. And one of the difficulties and one of the things that you're going to see a consistent pattern on is guardian ad litems who are making life difficult for parties. Sometimes you get a good guardian ad litem that can do their job, and they put in the work and they do what they need to do for the best interest of the child. Too often you see some that are just not doing the work, and they're more of a hindrance to the relationship than anything. In his situation, 7 months, a long time to go without having seen your kids, with no allegation, no hearing. So there's probably more to that story than than what we understand. But I will say this: when you have a situation where something is not happening, you have to file a motion. You have to get in front of the judge. You have to force the issue. And that would be the first thing that I would look at if I were representing him. I would also want to hear from the guardian ad litem and find out what the story is as far as, what the client is saying. But I think that in any situation where there's, time, Richard Gardner says in his book, Divorce Poison, that time kills custody situations. And the more time that goes by, the harder it is to get that relationship back. So don't let time be the the death knell. We've recently gotten in a case here in Oklahoma that is a parent who has not seen their child in years, and there hasn't been a clear allegation against the parent. There hasn't been an evidentiary hearing. And so we got into the case and hope to put a hearing on fairly soon as far as, the case goes. But this happens, and sometimes it happens as a result of parties not taking action and not forcing the issue. Maybe they're pro se, maybe their attorneys are not being very aggressive. They're not putting the issue in front of the judge very quickly. But sometimes it's because guardian ad litems they're not doing a very good job. It's sometimes the judge isn't allowing the case to be heard. And so there are situations that are kind of beyond anybody's control. But as far as what the litigant can do, and as far as what any of us as parents can do in a situation where we're not getting to see our kids, if there is not an order in place that says why, we need to be in front of the judge as soon as possible, asking for that time. This is a constitutionally protected interest that every parent has a right to a relationship with their child. And if there's not a clear finding of fact as to why they're not getting that relationship, they need to be in front of that judge as soon as they can be.
You want to add anything to that one?
Well, Chris might get mad at me, but it's our position. If guardian ad litems, their initial purpose for it is great, right? But the problem with it is that time and time again, we're seeing too many GALs that come into it. They're supposed to be experts, right? They're supposed to be an expert. They're supposed to compile. They're supposed to have an order from the court that is very specific to what their job is supposed to do. And unfortunately, we've seen time and time again to where GALs are getting these powers and these judicial powers to where let's put it in the GAL's hands. Let's increase visitation based on the GAL. That's not the way it's supposed to work. So, I mean, our position at our firm, unless absolutely necessary, we typically try to fight the appointment of a GAL.
Good lawyers ought to be able to represent their clients and put the evidence on without the need for a guardian ad litem. Guardian ad litems too often, in our opinion, are taking the place of courts, and they're acting as fact finders, and that's not what they're there for. And so, it's tough. It's a tough position because guardian ad litems are appointed in most of your custody cases. But it's, you've got, as an attorney, your role is to make sure that they're doing their job. And there are some very good ones out there, but there are also a lot of them that are not. And I'm not afraid to say that, but, but judges defer to them. And it's the world we live in.
All right, guys, I'm going to get on to the next call.
Hey, Eric, and Chris, hopefully for the broadcast with Chris on there, because it's kind of a question for an attorney. But first of all, thank you for having Dad Talk. I don't really want to leave my name because I'm still in an active case, and it's kind of a unique case, but I'm going to provide some details on it. I'm down in Texas. But my question is, where is a deterrent for the behaviors that sometimes you see, often with women getting away with something, obviously men do sometimes too, but the law exists as a way to have some deterrent from criminal behaviors and things like that, right? So in my case, attorneys that I've had, that I've hired and paid, they've told me, no one's going to prosecute for multiple felonies. No one's going to prosecute for concealing a ward, which is like parent kidnapping. No one's going to prosecute for 2503. No one's going to prosecute for paternity fraud. No one's going to prosecute for marriage fraud. So I had the thought, what about civil suits? Not that anyone has any money once they've gone through custody battles, but what about civil suits as a deterrent? Have you ever heard of that, Chris or Eric? Anyway, hope to hear y'all this evening on the show. Thanks for having me. All right, have a good one.
So, what you guys? I mean, I have heard a lot of talk about that. Over the past couple of years, people wanting to take these civil suits out for these, people that are making these allegations. I think there is a very severe lack of consequences for what we're seeing being used inside the family courts. Any comments on the caller?
I'm going to try to be fairly diplomatic about this answer, but I think that I understand why his attorneys are telling him that. I think that they're probably telling him the truth. But again, this comes back to judges, and I'm going to continue to put an impetus on judges to do the job of protecting the process, protecting the fact that parents who are bad actors don't get away with something because they're one gender or the other. It shouldn't matter. It shouldn't matter. So I think that, in terms of the comment that there's multiple felonies, felonies, that the district attorney is going to have to make the decision as to whether to prosecute a crime. So that's up to the DA. As far as what's going to happen in a family law courtroom, if most states have adopted or are adopting, or it's being discussed, some consequence for false allegations of abuse, and making sure that there's some sort of teeth for a false allegation. And so, one of the things that I think that you can look at, and I don't know that a civil suit would be cost effective. I don't know that it would be practical, but I think that using the tools that are at your disposal in a family law courtroom in Texas that's the first step. But again, if we don't have judges who are going to apply those statutes, it doesn't matter how good your attorney is. It does not matter how aggressive they are. It does not matter how effective they can argue a case. It doesn't matter how well it's briefed. It does not matter how well you've prepared. If you have a judge that is just not going to listen to it, they're not going to apply the law, they're not going to pay attention to due process, they're not going to pay attention to the Constitution. It just doesn't matter. And so that's why it's so important that we have judges in these positions who they take the job seriously. There is no more important courtroom in a courthouse than a courtroom that hears a family law case. And I think they get minimized too often. And so judges should take their job seriously. There's no other courtroom that sees more constitutional questions. There's no other courtroom that sees more impactful issues. There's no other courtroom in the courthouse that tries more cases. Maybe a criminal courtroom might, but family law courtrooms try cases. And so that's why it's so important to have family law judges who are really good. They should be the best judges in the courthouse. And I hope that we can as a group of people who are interested in the issue, I hope we can continue to have that conversation about how important judges are. But I will say this. I think there is a role for civil suits in this conversation. And in Texas, in Oklahoma, I will say that I think there is a role for that. And it's something that I think should be considered on a very specific case-by-case basis. That's probably the most I probably need to say on that issue. But it's something that I think there is a role. There are opportunities for causes of action in terms of civil cases if the facts are correct. Now, most family law cases are going to involve an opportunity to use abusive process claims, their sanctions, contempt. There's opportunity to do these things. There's a remedy within the family law courtroom for a lot of these issues. And so most courts are going to say that there's a remedy for that. Go to that courtroom. That's where you need to address this. And so that's why I say it's a very specific case-by-case question. Texas is unique in some respects because of their code, their family law code and their civil code. And so I think that it's an interesting question that he asks. It's a very complicated question in terms of what the remedy is and how to hold people accountable when they're a bad actor. And that's why I say ultimately you got to look at the judges. And if we have judges who are not doing that, hopefully you can either vote them out of office or vote the judge who hired them out of office. If you're in Oklahoma City, you've got a judge in the family law courtroom that was appointed by district judges. You have special judges, and so they're appointed somewhat like a magistrate would be in federal court. And so, from an accountability perspective, the judge that you're looking to from an accountability perspective is the elected judge that hired them. And so Texas, a little bit different. Other states, every state's different in that regard, and every county is different. There's counties in Oklahoma, most counties in Oklahoma, you're going to have your family law case heard by an elected judge. And so that's why it's really important that this issue is addressed at the judicial level, not just at the attorney or the case level.
Gotcha. You got anything to add to that, Tommy?
The laws need to be enforced. I mean, that's it. We have the laws that they need to be enforced, and if we're not enforcing them, we need to change them. There's got to be something, and I hate it. I wish we had jails and prisons that we could fill all these people who make these false allegations up, but it doesn't happen. So there has to be a way to use that against them. So for us, if we can get somebody, we can catch them lying, and we can get them, they're committing perjury, then we will use that in the case against them and make sure that the judge knows that, hey, this person, if you're talking about a custody issue and this person's caught lying and making all these false allegations and all these other things, then how can custody be awarded to that person? Now, getting to that point is exactly why we're all here, because it takes so long to get there. Yep. But the law's got to be enforced.
Hey, if I can just chime in real quick on this false allegation issue, because this is something that's consistent throughout the entire Dad Talk Facebook page. It's something that we see throughout. I don't think it's smart for us as a group of attorneys, parents, anything, to treat every allegation that's being made against a parent as false. And I think that we get a bad name for people who advocate for parental rights, for father's rights, mother's rights, that every allegation is a false allegation. And that's not the case. Every allegation should be made in good faith. I think that should be a precursor. And if it's a bad faith allegation, it needs to be held to account. And that's where it can be a good faith allegation that is false, and that's okay. I honestly think that's okay. I have seen children who have made disclosures who were in environments where they truly felt like that was what they were supposed to do. And their atmosphere of accusation was swirling around them, and they felt like that was what mom and dad, or mom or dad, wanted them to do. And they made an allegation, and that allegation was fleshed out. It was a false allegation. It wasn't a bad faith allegation. And so I think that's where judges, again, become so critical, in that you can have a good faith allegation that is false, and it can have incredible ramifications. But if judges aren't doing their job, and they're not doing their homework, and they're not studying the issue, and they're not reading, and they're not paying attention to the literature and the academics on this subject, they're going to make bad decisions that are going to have ripple effects throughout our entire society. And that's what we're seeing right now. I think we're seeing laziness. Now I get off my soapbox, but I
No,
think we have to be careful here.
No, and I'm with you, because the thing is, there is a lot of these cases where this stuff is true, and we can't forget that there's got to be the balance here. But I think many times those judges err on the side of the caution, especially when it's these extreme cases. I mean, I was completely new to this, man. I didn't go through anything like that, and I had all these parents calling up talking about the silver bullet. And I ain't gonna lie to you, Chris, when that first happened, I was like, I ain't doing it. I erred on the side of caution. That's the last thing I want to think that, I could possibly trying to speak up for somebody that done something like this. But that's also the dangerous side of it, right?
Yeah.
We should be doing our homework. That is a serious, serious allegation. And if somebody can fight it off and it was a false allegation, there should definitely be some jail time in my mind. Because I think if you put those consequences there, you'll see this stuff. It's not going to completely go away by no means, but I do think it will help.
Yeah, and that's where it's just I come back to the fact that if you have attorneys that do their homework and they understand the issue, and you have judges who do their homework and they understand the issue, and if everybody is moving in the direction of fairness and due process and equality on both sides, then we have a system that should work. Where the system breaks down is where you have people. Judges, you have human beings who are not doing their homework. They're not paying attention. They have a large docket. They want to just move things along. They don't want to give, you may have an hour to present evidence of abuse that is going to change whether or not a parent gets to see their child for the rest of their life. I mean, it's possible. And so that from a systematic standpoint, there are issues, but I think that I welcome if there was an allegation that is made in good faith, I think everybody should welcome it. And that's where our system is there. Just like if there is an allegation of a crime being committed, you have a right to a jury trial. You have a right to, the system is there to try to protect and provide due process. And that's where I think our family law courts have failed us in a lot of ways, is the breakdown of due process and the breakdown in the presentation. And I can get on my soapbox again as far as the need for a clear and convincing standard as it relates to the termination of contact between parent and child. That's probably for an entirely different show. But I think that's where we need to be having this conversation, is that, look, allegations can be made. They might be false, they might be true, but if the system works, then everyone should be treated fairly. And where it's broken down and where you're seeing a lot of frustration on both sides, it's not just dads, it's also moms. Yep. You're seeing a lot of frustration in that the system itself is failing them. And that's the issue. It's that the system has failed that parent by not giving them an equal opportunity to present their side, to treat them fairly, to look at their evidence fairly. And that's where I think we're really failing a lot of our people. And I think it's why in 100 years, we're going to look back and we're going to realize our family law system was an abomination. And our society is going to be ashamed that this is what we did.
I'm with you, brother. All right, I'm going to get on to this next one. This is our fourth caller.
Hi, Chris. This is Jeff Morgan from Dallas, Texas. I know you're a Christian attorney and in family law. One of the questions that I've had is, how is unilateral no-fault divorce even considered to be constitutional? It violates a person's due process rights. It is that to which there is no defense. The petitioner always wins in a divorce lawsuit because he or she gets a divorce. There's a way to bar the lawsuit and a way to win the lawsuit. And I also think it's a big religious liberty issue, because if two people get married in a church, they make a commitment and a vow to God. Why is it that you can be married by a pastor or a priest or a religious leader in the state for no reason can come in and dissolve that marriage? That seems to be a big, big issue. There are other issues as well. And I just want to hear your thoughts regarding the issue of unilateral no-fault divorce. Again, unilateral particularly, because unilateral divorce is forced divorce, divorce on demand. Whatever the petitioner alleges, they get it. And I'd love to hear your comments. Thanks so much, Chris. Great having you on the show. Thank you so much.
So as you can tell, Jeff Morgan.
I knew Jeff was going to get me. He was going to pin me down sooner or later and get me to answer that question.
Yeah.
Yeah.
So he is very passionate on no fault divorce.
He is. I will say that I'll give the quick answer, which is constitutionally, marriage is left to the state. It's governed by the states. The states get to pass laws. The laws govern marriage and divorce, and that's the constitutional issue. Now, he raises a really interesting due process question, and he raises some very legitimate questions as far as what we're doing as far as no fault divorce and what the impact is as it relates to other issues, religious liberties, due process, those things. And so I will say this, Jeff knows I'm going to need to spend some more time on that issue before I have a more substantive answer for him. He knows where to find me, and I'm happy to have that conversation. At some point when I have a good answer, he'll be the first one that I probably provide it to. But I will say that I wish I've said this for a while. When I can get you divorced for less than the price of an iPhone within 10 days, something's wrong with our society. So, and in Oklahoma, you can get divorced. If you don't have kids, you can get divorced in 10 days. And the filing fee is what, Tommy? $250. So, so you can get divorced in Oklahoma in less than 2 weeks for less than the cost of a cell phone. That's
these guys are saying, where's that at right now? He's talking about an amicable divorce.
I'm talking about an amicable divorce.
With no kids.
It's not contested and no kids. But that begs the question of, if you do enter into a divorce or a marriage that you believe is sanctioned by God, and you went into this as a covenant, and then one side just decides they're going to break that contract, they get to break that contract. And so there's some conversations that need to be had as far as how we view that. I've advocated in Oklahoma, we haven't gotten it done. Back around 2000, there was a big movement for covenant marriages. There's about 3 states that I think passed covenant marriage laws that basically said, if you enter into a covenant marriage, you can't get divorced without cause. That was generally the biggest issue there. So and then it kind of died on the vine around 2000, 2001. It kind of went away. And you don't see the movement. You don't have the conversation as much as you used to. I wish that states would pass laws that would allow for couples to prenup or to enter into prenuptial agreements that govern more than just property and money. Right now, they can only enter into agreements that govern property and money. If they could govern issues such as, we're going to go to counseling before we get divorced, we're going to, and I've advocated for a covenant prenup that would allow for couples to govern their marriage in ways that were more in line with a covenant marriage, and allow them to govern that. It hasn't happened. It's something that's probably a long way off, but it's something that I think that is a conversation I wish more people would have. And I appreciate Jeff for what he does for this issue, because I think it's an issue that needs to be had, and it's a conversation that needs to be had as it relates to marriage in this country.
You know, he was the first person that ever brought that one up to me. But since then, I have heard that become much more of a discussion. More and more people are looking at that no fault divorce. So, but we are going to get on to our next caller. We got about 7 or 8 more. I want to get these with you guys.
Hi, good morning. My name is Mia. We have a very intense court battle over my grandson who's been physically abused. The stepfather was arrested. The court is in Palo Pinto, Texas. I am the baby's paternal grandmother. I am asking for a conservatorship. The baby is now with the abuser's mother, who is not party to the case, who is no blood relation. And so I am going in on the 28th, but there's a lot of petitions by opposing counsel that are all lies, trying to speak lies against me and my son, who's the dad. So I need to know what the law says about my rights as a paternal grandmother, requesting conservatorship for my grandson, since he is with a stranger, not party to the case, no blood relation. Hoping to hear from someone. We are on the East Coast. My son is in Colorado, and the case is in wonderful Texas. Thank you very much.
All right.
I want to be careful. It's not advice. We're not providing any kind of legal advice. So I'm going to speak in generalities, and if it needs to be a more specific conversation, I'm happy to talk to Mia. In Texas, elsewhere, a parent or grandparent doesn't have an absolute right to their grandchild or visitation with their grandchild or rights to the grandchild. A conservatorship is comparable to a guardianship in some states. For example, in Oklahoma, if it were determined that a child is at risk of harm without court intervention, and the guardianship could be entered. Just last week, we had a grandparent guardianship entered on behalf of a grandparent who got guardianship over their, I believe, 4-year-old grandchild. So it's something that can happen if the parents of that child are not fit. Essentially is what you have to prove. And so in Texas, it's comparable. And so that's one of the things that I think you'd have to ask yourself. And I couldn't tell from the call whether or not her son, who's the father of the child, is unfit. It sounds to me like that I didn't hear that. I heard that she was asking for placement of the child with her. And I don't know that would be appropriate if that father is, by all intents and purposes, a fit parent. And so it's a very specific factual question, but generally speaking, and Eric, we've been dealing with grandparent issues and other cases that we've talked about, and come into run into the fact that in Idaho they don't even have a grandparent visitation case or statute right now. So generally speaking, for a grandparent to have visitation or custody of a grandchild, they have to show that either the parents are deceased, incarcerated, or otherwise unfit and incapable of parenting that child. And that's the rule of thumb. And so it's a complicated situation when a grandparent comes in and says, we would like to get rights to this child. Well, are you willing to say that your child, your son, your daughter is not fit to parent that child? And that's where a lot of times the conversation breaks down. Some, it's pretty clear. And those are the ones that I think are proper grandparent cases where conservatorship, guardianship is appropriate whenever it's pretty obvious. Our child is dealing with a substance abuse issue. Our child is incarcerated. Our child is otherwise just unfit. And as his parents or her parents, we're willing to say that because we know that's the case.
I was saying, or dead if one of them had
or
passed
deceased.
away.
Yeah, that's the and that's the situation we're dealing with them in the Mast case, as far as the need to get grandparent visitation for the Mast family. And so I would like to see the facts of this situation more specifically before I could really comment on it specifically. But generally speaking, if you're a grandparent and you're wanting custody or visitation, or conservatorship or guardianship over a grandchild, you're going to have to show that both parents are unfit, including your own or in your own child. So that's the rule of thumb.
You got any comments on that one, Tommy?
Grandparents, and we as a society, more and more grandparents are unfortunately raising grandchildren.
Yep.
It's just starting to become more and more of a thing, and really, unless both parents are unfit or you have some type of issue, drugs, alcohol abuse, something like that, then generally the rule of thumb is the parent who's not unfit is going to get custody. So there are things like guardianships and different things, but they're so state specific. You'd have to look at the laws in your state for further guidance. So.
All right, guys, I am going to get on to this next voicemail.
Hello, David from upstate New York. Wife made a false claim to CPS, and my daughter had to go through a rape kit where there were photos taken of her private parts and having to be swabbed. It never happened. I'm wondering what criminal charges I could file against her and have her arrested and put in jail. I just need to know those type of things. My daughter is everything to me, so I'm trying to figure out what I can do to save her from this monster. Thank you.
Chris, and
as far as the criminal issue,
go ahead.
Yeah, I as far as the criminal issue question, you'd have to start at your local law enforcement agency, your local police department. That would be the first place to start. If there is a false police report, a false claim, if they're willing to pursue that, that would be where you would start. And I don't want to. That's a tough sell with law enforcement who are dealing with a lot of different issues and they've got a lot on their plate. And so false claims in family law court is sometimes a very hard sell for a detective to go pursue. So, but that would be the criminal question. And as far as other options, that's going to be specific to your family law case. Have no desire to comment specifically on New York. But I'll tell you, in Oklahoma, as far as what we would look at, if there's a false allegation, a false claim, and it was determined to be false, the court can use that in their determination of custody. They can consider that as an issue in awarding custody to the other parent, or they can award fees and sanction that other side and hold them in contempt. So there are mechanisms in a lot of states when there has been a false allegation made. And as again, I say bad faith. It's it's really a bad faith allegation, not a false allegation. I've been guilty of using false allegation language but we're talking about bad faith allegations where we know that they're false and we just make the claim. There's mechanisms in most states as far as using contempt, sanctions, and attorney's fees to try to deter that.
Absolutely. All right, guys, I am gonna roll. I'm just curious, these rape cases or the allegations of sexual abuse and how this is used in family law. Did you guys know you would hear this as much as a lot of us are hearing now before you got into this? Or did that kind of catch you by surprise?
You mean as far as the number of sex abuse allegations?
Yeah.
I grew up interning in the DA's office in Oklahoma City. So my first assignment as an intern was on the sex crimes unit. So I kind of grew up understanding that these things were happening. But as far as just the frequency that we're seeing, I think that's a it's an anomaly. I don't want to say anomaly. It's a societal thing. We're seeing more of it. I think that we are seeing more of it, and that's anecdotal. I don't know any specific data to be able to say that there's more allegations today. I will say that all of the academic literature that we rely on today, that came about in the early to mid 80s. And so this is not an issue that has been studied over the last 100 years. This is something that has been studied for the last 40 years. And so, there is more literature on it today than there has ever been. And so as far as sex abuse allegations, there's a lot of data on it, and there's a lot of information on it, and there's a lot there. And I just posted a blog post to our website about bedwetting because we're seeing a lot of allegations. It seems like that every time there's a child regresses, if they've been potty trained and they're making it through the night, and then all of a sudden they start bedwetting again, or they're having more accidents. It's not long before there's an allegation that there's been some abuse that's gone on. And so that's not the case. We see a lot of data on regressive behaviors in children who are going through high traumatic experiences, going through a divorce, their parents splitting up. That's a traumatic experience. It's not unusual to see regressive behaviors in that regard. So I think that there's definitely a rush to make an allegation of sexual abuse in a lot of situations where there really shouldn't be. And we've tried to deter clients in our in our practice. Let's hold tight. Let's watch it. Let's monitor it. Let's make sure that we're being conscientious of it. But let's don't rush to judgment. Let's don't jump right in, because the remedy can be just as damaging to the child as the issue of the alleged abuse. And so we got to be careful in any case. If it's a false allegation that's not true, putting that child into the system of sexual abuse allegations can be very traumatic in and of itself. So we want to make sure that anytime we make an allegation, it's well thought out.
Tommy, you got anything to add to that?
I know we've got more calls, but the one thing that I think is very important, and especially as us as attorneys and then litigants, everybody that's in this system, they need to realize that when it comes to kids, and I tell people all the time, well, what's your win record? What's your loss record? When it comes to custody cases and visitation issues, kids are the only ones that lose when parents can't figure out a way to work it out. And that happens time and time again. And what you do is where the shock factor is that we're seeing parents who in one breath post pictures on Instagram or whatever it is that says, world's best parent, and we're this great family. And then in the next minute, they're using that child as a shield and shielding it like a sword against their ex to try and get a win. And that's where we really go wrong. And I love the bad faith. Was this allegation brought in good faith or bad faith? Did you truly believe that your ex was touching the child, or are you going into it knowing that you're only doing that so that you can get an advantage in your custody case? Then the law, legislators and judges and attorneys need to shield that weapon back and level the playing field. So that's my 2 cents on it.
Absolutely. I love that, man. All right. I am going to get on to this next call right here, guys. I think we got about 6 more. I've had some that came in while we're on the show. We won't be able to get into those tonight, but in any of those before we started, I'm going to try to get to. So here is our 7th caller.
Yes, hi. I'm Bradley Jacques. I'm from Alberta, Canada. I'm going through family court trial right now, and it seems any time that me and my kid's mom are in court trial, she acts different and starts to try to talk in ways of trying to make statements for court to try to use them as evidence in court. An example, like my son has just recently, he'll be 3 in March next year, by the way. He's just recently stopped taking his naps when he's with me. I'm unsure if it's a form of sleep regression. He does sleep throughout the whole night. He just won't take his naps. She's trying to claim that it's because he doesn't function well with me and he would be better off without me. She's not allowed around us because we have a court order of, it's a mutual no contact order with exception of communication only through the Our Family Wizard app. We use a place called Monitored Exchange, and it's where I wait in a room with my son and the staff bring my son between us. So I never see her in person, but as of lately, like this is his 3rd weekend this weekend that he went back and he was tired only when we arrived. But all day yesterday he was wide awake, he wouldn't take his nap, and he's just full of energy. I don't know if maybe there's something I can do better, or maybe if it's just because he's so excited and so happy when he's with me. Also, on top of that, since this started, he also, at Monarch Exchange, when they open the door, he no longer runs out that door excited to her. He actually runs to me, hugs me, and cries. He doesn't want to leave. And she's trying to get into my head, I know, and make me feel like I'm a bad father and telling me that see, Brad, he would be better off without you. He doesn't need you, and you're ruining his schedule. And apparently she claims that he goes to bed at 7 or 7:30 every night, wakes up at 7 or 7:30 in the morning, and has his nap right after lunch every day, no problems at all. And I'm sorry, but he's not a robot. I understand that. And I guess I'm scared a judge is going to possibly believe her listener and even use this to take him from me. Here's the kicker too. Not this past October, but the October before it got found by DNA test that she asked me to do that he's not biologically my son. However, the courts see me as his father because in Canada we have a law called loco parentis, which is Latin for stand-in parent. I was made to believe I was his father, his biological father. I was there the entire pregnancy. I was there for his birth, and I've been consistent every single weekend since we broke up. I have him every single weekend. This has been in the courts for a year now, and we're just going to trial. Trial starts in January. It's stressing me out. She is getting into my head, I know, but yes, I am Bradley Jacques. I'm from Alberta.
It cut him off. Wow. There was a lot in that, guys.
I feel for him. I think that it's what he's dealing with is there's a lot of dads who deal with that and a lot of parents who deal with that. And it's the dark side of our system is the fear. Parenting in fear, parenting under a cloud of accusation and fear. And so, as far as the question, I don't know that we even got to the question itself, but I think that one of the things that I would tell a father in his situation, if they were our client, is you need to operate as if you are under a constant microscope, because you are. Everything that you do is being watched. Every move you make is being watched, and it would not hurt you if you're concerned that there's going to be an allegation against you. It does not hurt to have a family member present during visitations. It doesn't hurt to make sure that you're doing everything you can to document. One of the easiest things for us right now to use to document life is our phones. I mean, everyone has a cell phone with a camera on it. That camera will date stamp and geo stamp your photograph and time stamp it. So you can be taking photos of you and your kids throughout your entire interaction. And you've got a pretty good narrative that's geo-tracked and date stamped and time stamped. And nobody thinks anything of it because you're just taking photos of you and your kids. So if there's an allegation that you're not at a visitation, or if you're not at a drop off or a pickup, or if you're if there's an allegation that you're doing something.
Uh-oh. You still with me, Tommy?
I'm here, brother. I'm here.
Man.
We'll take all the callers.
Chris
Who knows
Slack.
what happened? He probably forgot to pay his internet bill. Either that, or he's I don't know. Who knows what's going on with him? But I kind of want to address something that is important, right? And it's something that everybody can go through. So I don't know if you know or not. I was a veteran, and I served in a place called Afghanistan. And one of those things that me and my friends, when we come back, one of the hardest things to deal with, right, is going and talking to somebody. Well, I didn't really have it. I'm sure I had issues, especially if you ask my ex-wife, but I didn't. The things that got me and really drove me, I would say, insane, was when it came to the divorce and going through anything to do with my kids, right? So what you heard in that caller's voice was this anxiety, right?
Yeah.
She's going to say this, she's going to say that. The kids are perfect at moms, but he said something about robots, right? The other parent, when you're in a custody battle, is always going to try to win in a text message. Well, this is new. They go to bed at night at 7 o'clock, and they get up at 7, like they're robots. And most judges know that that's not the truth. But what you have to do is, instead of using that opportunity as a chance to argue back and forth with them, take a step back and address that. And one thing that I didn't finish when I went into the military and the anxiety and all of that is go and talk to somebody, a professional. Attorneys charge you, they're like slot machines. I tell people all the time, it's cha-ching, cha-ching. It pays to have a group, a support group. I mean, just like the Dad Talk Today support group that you have, I'm a member of. It's awesome, where you can get with other like-minded people. Try and get outside of your friend circle, your really close friend circle, because then you can get different points of views. But don't be afraid to go and talk to a medical professional. Mental health is so huge, and I never thought I'd become as big of a mental health proponent as I am today, doing family law and then going through my own divorce and trying to co-parent every day and trying to move on to your next chapter and raise kids. So big proponent of that. As Chris keeps coming in and out, I think we go to the next caller. I don't know. What about you, brother?
I think that's what we're going to have to do, man. Chris, pay that bill. All right, guys, we're going to get in here to our 8th. Well, I mean, really quick, and I know we're going probably way past what I'd originally thought. That's one thing I've noticed. I just started taking the call-ins about a week ago. You mentioned hearing that emotion inside of that caller's voice, and you've been through this before. Is that something you recognize it?
Oh, it's real.
Yeah, man.
It's real. And I mean, even people got to remember too, is it's even harder being in those shoes, right? And being on that other side of the table. And now that I'm the attorney, and one of the main important roles is to say, hey, slow down. Let's take it one piece at a time. But it is one of the hardest things to do, because anybody who has faced a bad faith allegation and has had to defend themselves in a custody battle. I mean, I would rather go to Afghanistan and have a summer vacation home every year than to go through a divorce again. And I mean it. I honestly mean it. It is one of the worst things. I don't wish any of my worst enemies. And there are people, everybody that's in the chat talks about GALs making money, judges, all these. It's just the way that the system is. The thing that we have to do, though, is we have to take a step back. You have to take care of yourself. And that's why when you feel yourself, hey, I am obsessed with this, and it's my kids, and that is, I love that, and I respect that, because I was that. But that's the moment when you have to take that step back and say, okay, I need to make sure that I'm good so that I can move forward for my kids. Because if you get an attorney on the other side, they'll take advantage of that every time. And if you fall for that trap, they'll paint the picture that this person is unhinged, and that does not help your case. So, Chris,
sorry for the technical difficulties. That's what happens when you have a child underneath your desk. Unplugging. She unplugged my computer. I didn't see my battery life dying as we were sitting here.
Oh, that's crazy, man. Hey, it's live video. It
This
has
is
been.
why, listen, I can empathize with fathers, with dads, with mom. I can empathize, like, because I've been here and dad's so hard myself, so I get it.
All right, man. Well, I'm going to get on to this next call, guys. This is caller number 8.
Hey, my name is Tyler, and I am a single dad of a 5-year-old girl. Her mother has altered our parenting plan on her own. It's not a court order. She does not work. Her new husband does and supports them on that side. I don't have that luxury, and she's a stay-at-home mom. She gets to pretty much dedicate all her time to our daughter and her 2 other kids. I work full-time to support my life and my daughter's life when I have her, and I only get her 2 or 3 days out of the week because of my work schedule. I was wanting to know what kind of options do I have as far as being a single dad and wanting to spend more time with my daughter and get her 50-50 as the court order says, but not really being able to do that because I don't have child care to actually have her 50-50, like a week on, a week off. Hey, my name is Tom.
I didn't catch where he was located, but I
didn't either. I was thinking the same thing.
I think that he's going to need to just stay the course and fight the fight and know that he's a working father. There is no penalty whatsoever for being a working father. There shouldn't be. Just like there shouldn't be a penalty for being a working mother. There should not be a penalty for dads or moms who are working and trying to provide for their family. And so that's something that he needs to stay the course on. And if the court's going to come in and say, look, well, you're working, and now I don't know the child care situation. There's going to need to be child care. Obviously, you can't just leave a child depending on the age. I don't know that I caught the age, but need to make sure that we've got child care for the children. In Oklahoma, if it's employment related child care, then that could be part of the child support computation. And so what we would look at in that situation is whether or not child support needs to be offset to make up for the child care that he has to expend. But I think that he's winning right now as far as he's got 50-50 time in his court order, and he needs to just stay the course on that and not allow for an attempted modification just because he's working. And so that's what I would say. Now, I will say this: if he doesn't have child care for his children, it's going to be hard for him to hold on to the 50-50 time if child care is necessary and in the best interest of the kids. If he's got a 4-year-old that can't stay home by themselves, then he's going to have child care. If he's got a 16-year-old that can stay home by themselves, then it's not that big of a deal. So it just really is fact specific based on the child care situation.
I think I got a dog outside running into the building. Mommy, you got anything to add on to that, man?
Just protect it. She can't, if you have a court order that says you have equal time, equal visitation, then you're going to have to figure out a way to tell her, look, you can't unilaterally change this. I want to work with you on it. If you want to do the child care so we could save money, I'm cool with that. But when I get off work, just like it would be a regular child care provider, I'm going to come pick up the child per our court order until it's changed. And you just got to kind of stand your ground on it. A lot of factors go into it. That's not legal advice, but stick with that order. That court order is going to prevail.
Yeah.
All right, guys, I'm going to get to this next call.
Hi, my name is Blake Valentine. I'm calling from Southeast Texas, and I have a question in regards to divorce court. So we've been going to court in Texas over here, and things haven't been going my wife's way. So she decided that she was going to file for divorce in Louisiana. Well, now I had to hire an attorney over in Louisiana to try and take care of this matter. So there's a jurisdictional issue. Now she's telling me that because she left with the kids and is living over there in Louisiana, that Louisiana is going to take over. But, you know, my lawyers are telling me otherwise. And basically I just wanted to clarify, you know, who actually has jurisdiction, because we lived in Texas and I filed for divorce here. So, you know, she's got the kids over there. And, you know, as of now, I have temporary sole custody. I just don't have possession of them. So if you could shed some light on this situation, that'd be great. All right. Thanks.
I think listen to his attorneys would be the first advice. I think his attorneys are telling him correctly. I think that Texas would be the appropriate forum and the appropriate jurisdictional location. And so if he's still living in Texas and the case is in Texas and was originally filed in Texas, I would be surprised if they allowed it to go to Louisiana, even if she moved to Louisiana. Now,
I agree, Chris.
Well,
there he is. We see you, Doc.
all I see is President Abe Lincoln in the back corner.
Shoot.
Oh, now we hear you.
Yeah.
Can you hear us, Chris?
We'll let him figure it out.
Go ahead, Tommy.
So jurisdiction it's a tricky one. You know, essentially there's the Uniform Child Custody Jurisdiction Enforcement Act, the UCCJEA, which should apply across the states. But you want to look at when children are involved, what the home state jurisdiction is, and obviously I would defer to local counsel for how you should proceed. What is interesting, though, is that we are seeing a lot of cases, or I'd say more frequently, with the battle of the jurisdictions. You know, one party goes from state A, and now they're in state B. I think that it's important. You know, fortunately, when you do look at home state, for the most part, it will look back at, you know, where was the last 6 months did you live at? There's different exceptions. Every state is a little bit different, but generally you look at that and to figure out what the home state for the children would be. So interesting issue.
Absolutely, man. Chris, we got you back.
Nope. You should have stayed quiet. Almost as interesting as Mr. Smith's.
All right. I'm going to go ahead and move on to the next call here, brother.
Hey, guys. My name is Derek Smith, and I am calling from Kansas. My question for you today is, technically I have joint custody, but the mother of my kids is the custodial parent. Okay. However, with her being the custodial parent and us sharing the kids, I want to see my kids every day. I mean, I would love to, and it just seems like she's starting to do that more and more, which is great. However, with child support, funds are tight, and my question is, in terms of filing for dependents, even though she's the custodial parent, do I have any leeway to file for dependents, even though I do pay child support? Do I have to go to court to become a custodial parent before I file for dependents? And the reason why I said it is because when you file your kids in taxes, obviously you know that you get a certain amount of money per each child, which would definitely help during those tight funded needs. So just wanted to ask that question. Hope I put it into an easy question for you, and look forward to your answer. Thanks so much. Bye-bye.
You know, I think that might be one for a tax preparer, but I am sure, Tommy, you have heard that question numerous times.
Well, I'll be full disclosure, and this is not a plug for H&R Block, but that's who I use. Not sponsoring them at all, but that's what I use. No, essentially, so I'm licensed in Oklahoma. I'm not licensed in Kansas. Part of his question, I believe, had to do with the taxes. I'll just speak generally in that situation here in Oklahoma. Typically, you're going to have your order, and he talked about how they have joint custody, and then she's the custodial parent. So different states call it different things, but essentially, custody is legal decision making, and then visitation. So when we hear the term 50-50, things like that, 60-40, that's visitation. And those are supposed to be two separate things. So if you need to change whether he's the custodial parent or not, I would look at your local statute, so in Kansas, and then talk to an attorney who's licensed there. And then if there's an order that's already existing, most likely you have to file a motion to modify that. And then I don't mess with anything with the IRS, so I try to stay away from them. So
I hear that. That's a whole other word right there.
That's a whole. Mr. Smith, are you back?
I'm back. I can hear. Sorry about that.
All right.
An IRS question, but good luck.
I'm glad. I knew there was an IRS question coming, so I just stayed away from it completely.
I'm sure it wouldn't be the first time you guys have heard it. All right, I'm going to get to this next call real quick. We got two more.
Eric from Fort Worth, and got a question related to evidence and the 2-year statute of limitations of the status quo. So instance is where mom, who has primary custody, alleges that dad did something. The case drags on and on and on. The docket keeps getting pushed. It's been about 4 years. So does the evidence that was actually would be relevant if it was 2 years ago still apply, or is there a special motion that you have to do to preserve the evidence?
Good question, Chris.
I'm not entirely certain if he's referring to on the 2-year statute of limitations. Is he talking about a criminal matter? I'm a little lost. I'll say this. Generally speaking, if there's a case pending, it tolls the statute of limitations, and as it relates to anything relating to that case itself, and any evidence that's going to be relevant to the ultimate issue is going to be presentable. So, I'll leave it at that. I don't know exactly what the issue is. If there's a family law case pending and there's evidence that's going to be presented, it would surprise me if that evidence wasn't available to be presented if the ultimate issue has been pending, if it's relevant to the ultimate issue. So it's the question kind of cut off. It kind of cut off before I heard enough to really know exactly what we're talking about. But I think that you should be able to present the evidence that's relevant to the ultimate issue that's being considered by the court.
How did you pick up on that, Tommy?
I agree. I mean, it's the problem, and this is why law. We wish that we read one thing, but then you have case law and all these other things, and it's always gray and then squirrel and then gray and then squirrel. The statute of limitations, that is one issue, on whatever action that would be governed by it. And then the evidence issue, that evidence should be preserved and should be able to be presented regardless of how long it took to get there, as long as that initial action was pending. And if it's on the court for delaying it. That's why sometimes you see litigation cases that last years and years. And then in family law, unfortunately, there's cases that some people will get it done, 90 days, if that's your waiting period, or if your cooling off period is 6 months or wherever you're at. If you have kids, they might be on the front side of it. And then there's some guys and girls that take years and years and years to get through that. So it's just very specific.
Guys, thanks everybody for calling in tonight. We're going to get to our last question of the night. If you got in a little bit late and we didn't get to that, I'm sure we'll be doing this again sometime soon. Keep those voicemails coming in. I will be listening to the leftover voicemails in the morning at 10 o'clock a.m. Eastern Standard Time. Give us a call, 762-441-0281. Let's go to our last caller.
Hey, team. This is Mark from California. My comment is about license suspensions due to back child support. In August of 2022 out here in California, Senator Kamlager passed Senate Bill 1085, making it illegal for license to be suspended due to back child support. Kind of sounds like an oxymoron, right? Why would you have to pass a law for something that you need to make money to pay child support? But we're California, so, what can I say? Do other states have that? This question is for the panel and for Chris. Do they have it in Oklahoma? If they don't, would that be something that he would take up so that dads and moms, aren't getting basically crucified by the child support department and by the DMV just to make a buck? Again, appreciate everything you guys do. For everyone in California, Senate Bill 1085 protects you. They cannot suspend your license for failure to pay child support. Thank you, guys.
Every state's different. Most every state does have the ability to suspend a license if you're not paying your child support, if there's a significant arrearage. And so, but it's rare that happens because you need the license to make the money to pay the sport if you're making an effort. So, so I think that it's definitely, I'm going to go look at Senate Bill 1085 from California and see how it compares to our law in Oklahoma. I think it would be something that if it's, I will say that California has been fairly progressive in terms of a lot of family law issues. And I've talked to parents in California who are, they're pretty, it would surprise you. I know that, Eric, we've read the respondent and, that there's an idea that there's this really hostile environment in California, but then I've talked to a number of fathers in California who've had a very different experience out there and compared to the Midwest and compared to where we are. So California's done a pretty good job of trying to be fairly progressive as it relates to parental equality. But I would love to see, every state follow suit on things like license suspension if you're behind on child support. There needs to be some discretion. Again, this goes back to, where the people who are making the decisions, the judges and the administrative agencies, you got to look at good faith versus bad faith, and you got to make some, this is an equitable decision. And if someone's not acting in bad faith, if they're making an effort, if they're trying, but they're behind, it's, something that I don't think a license should be suspended for that. But it sounds like California is leading the way again as far as making this an issue that the rest of us need to take a look at as far as protecting licensure if you're behind on child support.
Yeah.
You got anything to add to that, Tom?
I do. So
All right.
Oklahoma, Chris is right. So it ebbs and flows, and it comes from the administrative court here, that kind of looks at enforcement and things like that for the most part. And the bottom line is that, when COVID happened, they eased, at the start of the pandemic, they eased a lot of the enforcement actions. Okay. I.e., hey, going after people's licenses, things of that nature. But now that we are out of the pandemic, you're going to start seeing a lot more enforcement when it comes to taking licenses and levying putting a bank levy against somebody and obligors, if they're not paying their support. The other huge crucial thing here in Oklahoma is they will take away your hunting license. So, and I know it's been hard to see you, Eric, Because sometimes
Yeah.
all I see is the head, but they will come after your hunting license here in Oklahoma, and that is something that many people care dearly about. So, you got to pay the child support if you get behind. There are ways though. Don't just ignore it. Either contact the agency that's coming after you and try to work out a plan with them, or speak to an attorney about that child support, but don't let it get too out of hand. So.
I'll tell you, that's one of the things that I've learned, that just don't stick your head in the sand. Don't be afraid of the issue. Address it. If you're behind on child support, work out an arrearage with the collecting agency. Most courts, at least in Oklahoma, will be pretty reasonable about arrearage payments, and so you can get a payment plan in place pretty easily. So don't stick your head in the sand. Just work with the agency that's responsible for collecting, and they want to get your case off their calendar, off their docket as quick as they can. So they'll work with you to try to make that happen. And so just don't ignore it. Don't stick your head in the sand. And the obstacle is the way. And so if you can overcome the obstacle, you're going to be better off for it.
I'm with you, man. It's crazy in Georgia. I remember back in the day when I was paying child support, if I got behind 1 month, I got a letter in the mailbox saying we're suspending your driver's license.
Right.
I mean, 1 month, and it was just because I hadn't got paid yet. They didn't play around, and I was doing everything I could. But I mean, every state is different. I do believe that's one of the ones that is getting changed in many states, because I think many of them have kind of stepped back and said, well, how do we expect these guys to make money if we take their driver's license? But I also know how that's a way to kind of make sure they pay it, right?
But I can see nobody, don't shoot the messenger, but I can see taking away a recreational thing, right? If you're not paying support, I can see, then you don't need to go hunting, or you don't need a passport to go to France or whatever. But to take away a license is idiotic. They need the license to get there. And most cities do not have bus routes or even safe bus routes. Like, okay, you suspend my license, now I got to go take a bus ride to work, and then I possibly get shanked and I lose my job. It's compounding the issue, which is kind of what I think one of the themes of tonight's show has been, is that we can't compound the issue, whether it's attorneys, whether it's the system, whether it's the legislators. We cannot, whether it's ourselves, compounding the issue. We just can't do it.
Absolutely.
I learned something tonight, that Tommy's got a secret expertise on municipal bus routes. I did not know this.
I do. I keep some in my pocket. I won't show you. Oh, this guy. Thanks for having us on.
I appreciate you guys coming on here and dropping this knowledge on these guys so much. Especially this week, I hope you guys have a good Thanksgiving. Anybody that's watching the show, we'll try to get this going again. This is a new format we was doing tonight. I hope you will join us in the morning. Give me those voicemails so I can listen to it. 762-441-0281. But before we get out of here, Chris and Tommy, if anybody that was listening tonight would like to get in contact with you, maybe need your services or need to talk to you about something, how can they reach out to you?
The easiest way is to give us a call at 405-843-1000, 405-843-1000. Our website is thesmithfirm.net. You can find us on Twitter at The Smith Firm, and Facebook, same thing, Instagram, all of the social pages. And so that's the easiest way to find us, reach us, send us a message. We're happy to engage, even if it's something out of state that we can't really represent you on. We're happy to consult, talk, work with parties to try to see what we can do to help, because we're advocates for making sure that people are treated fairly in the system. And it's not limited to just dads. We've got moms who are also, not treated fairly. And we're not afraid to say that, but we're both dads. It's a soft spot in our heart, and we want dads to be treated fairly. And so if we can help in any way, we're happy to.
Absolutely. All right, guys. Well, I appreciate you for joining us, guys. We will see you next time. Hey, everybody. Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also Super Chats, patreon.com/dadtalktoday, and other ways you can support our channel. Thank you for being here, and we will see you